Attorney, and Ms. Schucker for the state. This is the first appearance in this case. Ms. Fritz.
We have received a copy of the criminal complaint. I'll waive any formal reading, preserving all rights.
Okay, state's bond request.
The state is requesting a $250,000 cash bond. Conditions of installation of a scram device prior to release, CGS services, absolute sobriety, no bars, taverns, or liquor stores, no driving without a valid driver's license. Also conditions of no contact with the victims or their families. Their initials are SDH, JQC, CS, and then the deceased individual OLW. We would be asking for no contact with that family, the family of that individual. Obviously, this is a substantially serious case. It's an OW.
Obviously, this is a substantially serious case.
What's that?
Go ahead.
Sorry. In terms of the strength of the state's case, Mr. Wallace did admit that he was the driver of the vehicle. He did admit that he had been drinking prior to driving. I think the statement that he made was that he was driving because he was the least intoxicated of all the individuals that were present. In terms of injuries, obviously, this is kind of the most tragic that you can see in terms of an OWI offense. There was a fatality. In terms of the other occupants of the vehicle, there's a 17-year-old occupant who is sedated and on a ventilator at St. Vincent's currently, with information that he may likely be paralyzed. There are two other individuals who were transferred to Freightert, one via helicopter. One of those individuals is in a coma currently. So obviously, when you look at these injuries, they're substantial in nature. The strength of the state's case is significant. If convicted of really any of these offenses, prison is really a very certain sentence just based on the seriousness of the offense, so the potential exposure. I think that could increase the likelihood of being a risk in terms of flight. The PSA was done for Mr. Wallace, and it indicated that a cash bond would be appropriate. So based on all of those circumstances, I think that a significant cash bond along with those other conditions is warranted.
Well, a couple questions for the state. First, was there a PBT done, and if so, what's the result? And what history does Mr. Wallace have? The PSA mentions a misdemeanor conviction or convictions, but that's it.
Sure. So in terms of the PBT, there was a PBT done when he was booked into the Brown County Jail. Keep in mind, this was over 4 hours after the accident. The PBT at that time was a .069. In terms of prior criminal history, he does have a substantial prior criminal history in terms of probation and probation revocations. The first period of probation, it looks like, was a 2011 criminal damage. He was placed on probation. That probation was revoked in 2013. He also has a disorderly 2011 where he was placed on probation. That probation was revoked at a separate time in 2013. He has a intimidation of a victim out of Outagamie. He was placed on probation. That probation was revoked in 2013 at a separate time. He has a resisting or obstructing out of Outagamie, placed on probation. That probation was revoked. He has a 2016 Brown County possession with intent to deliver THC as a repeater. Read in at that time was possession of narcotic drugs as a repeater.
When was that?
That was 2016. He was placed on probation in that case. I don't have any information that probation was revoked. He has most recently only ordinance violations, a resisting or obstructing, and a possession of marijuana, both from 2018. And then in terms of bail jumping type offenses, it doesn't look like he has any prior bail jumping convictions. He does have a dismissed and read-in bail jumping from 2011 out of an out-of-gaming disorderly conviction case.
Okay, Ms. Fritz.
Commissioner, if the court is not inclined to set a signature bond, Mr. Wallace can post $2,000 cash bond with the understanding that the court would likely impose a scram unit, which he is more than willing to wear while this case is pending. Mr. Wallace has ties to the area. He has family in Green Bay. He has a residence in De Pere. He's currently self-employed as a contractor. He remodels houses. And he does have children that live with him and his partner. He has an 8-year-old and a 7-year-old daughter who stay with him and his partner in De Pere. He's been in Green Bay for over 15 years, so he does have ties to the area. As the state put on the record, he has no prior bail jumping convictions. His last convictions look like they were in 2016 or for a 2016 case. And as the state said, it looks like he did successfully complete that term of probation. The PSA does recommend a cash bond, which, like I said, if the court is not inclined to set a signature bond, he can post a $2,000 cash bond. This is a very significant amount of cash for him. It's not something that he's certain he'll be able to come up with. According to the PSA, he's had no failures to appear in the last 2 years, no prior violent convictions, and no cases pending at the time of this offense. I think that speaks highly of Mr. Wallace that there's no prior violent convictions. I would say that these type of offenses, although obviously are very serious, it's not necessarily violent in the sense that it is not intentional. These sort of offenses obviously are very serious in the sense that somebody has lost their life and there's some significant injuries. However, they are accidents in the sense that it was not a purposeful action of Mr. Wallace, that these individuals were injured or that an individual lost their life. He's very remorseful. He could also, on the scene, you could see that he was very remorseful as well when emergency individuals came on the scene. So we'd ask you to consider a $2,000 cash bond with the scram requirement.
Okay. So the charges obviously are very serious in that they carry very significant exposure. Mr. Wallace is being charged with 4 different counts, 1 for a death, 3 for what sound like very significant and serious injuries for individuals who are his vehicle when it was involved in the crash. PBT, I understand, was 4 hours later, but was a lower level. The complaint does mention the one sobriety test that they could do was positive, the HGN on all counts. So they're difficult cases in that, yes, correct, it's not an intentional act that's alleged, but frankly a reckless one. It does seem as though on the scene, Mr. Wallace was cooperative with the police. However, he's got a history of violating court conditions, and that's revealed by his revocation. I will give him credit in his last period of supervision. He did successfully complete that, but he previously had a number of different revocations. I think it sounds like some of them were probably the same revocation.
I was young. I was young at that time.
Mr. Wallace is 27 years old right now, and he's got quite a few convictions. He's got ties to the area. I think cash is warranted. $250,000 is frankly quite excessive for what this is. $2,000 is insufficient for what this is. Certainly, scram, no alcohol, no presence in liquor stores or taverns, no drive. I'm just going to say no driving at all as a condition, are all appropriate. And to ensure that he comes to court instead of $20,000 cash bond. No contact with family of OLW, no contact with SDH, JQC, and CS, or their families. And we'll schedule a balance of initial appearance then in 3 weeks. will be May 21st at 2:30 in the afternoon.
Sorry, I may have missed it. Did you order a scram?
I did.
Okay.
Sorry, I may have missed it. Did you order?
What was my bill?
Okay.
$20,000.
Anna, can you have someone from your office send over those names and date of births for the victims so we can do a conflict check?
Yes.
Okay, thank you.
You're welcome.
Yes. Okay, thank you.
Okay, Mr. Wallace, you're all set.
Who should they send that to, Tricia?
The clerical.